Thank you. Please be seated. Good afternoon. The First Court of Appeals has two arguments today. The first case is cause number 0114008868-CR, Ex parte Stuart Wheeler. Are the parties ready to proceed in this case?
Mr. Wheeler is ready, Your Honor.
Okay. The state is ready, Your Honor. And Mr. Bennett, how would you like to divide your time? You should have got a notice, 20 minutes per side.
Yes, may I please have 5 minutes for rebuttal, Your Honor?
Definitely. And if you'll just give us one more moment here. And the next case that we have is cause number 0114000133-CV, United Services Automobile Association versus Joseph and Joanne Hayes. Is that correct? And you should have got a notice 20 minutes per side, right?
Correct.
How would you like to divide? Well, I guess we have cross appeals here.
Well, actually, we talked about this the other day. Maybe this is a good time to...
Yeah.
I have a proposal for you, Your Honor. Jennifer Hogan.
Yes.
For the Hayes.
Yes.
Our proposal would be that we each basically have a rebuttal. And I discussed with Mr. Hogatanian, he had said that he would like to go 15 and 5. So I said, well, perhaps we could go 15, 15, 5, and 5. He said he's not opposed to that if that's what the court would like, but...
Sounds like a good idea to me. Okay, let's do that. 15, 15, 5, and 5. Great. We're going to go ahead and hear the arguments in the first case, and then we'll give counsel a few moments, and then we'll hear the arguments in the second case. Okay, let's proceed in the Wheeler case.
May it please the Court.
Thank you.
Thank you for granting oral argument in this case, because what we're seeking to do is to overturn the precedent of this court in State versus Maloney. State versus Maloney was decided on a presumption that the statute was valid. Ex parte Low was decided on a presumption that Section 33.021B of the Penal Code was valid. The Court of Criminal Appeals, and Justice Jennings, you wrote that opinion, I argued that case. We got it wrong. It's not your fault. I got it wrong as well. I didn't figure out...
And maybe the CCA did too, but...
Somebody got it wrong. So the CCA in Lowe said that where the statute is a content-based restriction on speech, it is presumed to be invalid. And then the state has the burden of showing the statute to be valid. There are other things that follow from the presumption of invalidity as well, which we might get into, but the foundation of Maloney was wrong. Maloney was founded on the idea that, and in the principles, the legal principles section of Maloney, the court, and Justice Higley wrote the opinion, and again, this is an area of law that is developing in Texas. It's not something that was clearly settled at the time where the litigators or the court were clear on how it would all shake out. But how it has shaken out is that a content-based restriction on speech is presumptively invalid. The state has the burden of showing that the statute is valid. The statute is invalid if the overbreadth of the statute, that is, the cases in which the statute could be applied unconstitutionally, are real and substantial. And in this particular case, the state hasn't met its burden. So the presumption wins the day, even, however, if the presumption didn't win the day. Something that we have here that the court didn't have in Maloney is real evidence, documentary evidence admitted to the trial court, uncontested by the state, that there's this thing called age play, which is sexual behavior among adults pretending to be ages other than they are, often children. The statute criminalizes age play. The statute is deliberately written to criminalize age play. That is, in subsection A of the statute, minor is defined to include not only people whom the defendant believes to be children, but also people who represent themselves to be children. And by implication, because there are these two separate subsections, A represents himself to be a child, B is believed to be a child, believed to be a child excludes merely representing himself to be a child, or vice versa. Representing himself to be a child does not require that the defendant believe it. So that's the first part. The defendant need not think that he is dealing with a child in order to be prosecuted under this statute. And the second part is subsection D. Under subsection D, the legislature has excluded two particular defenses which, if the defenses were allowed, if the defenses applied, the speech would be constitutionally protected. But the legislature has specifically excluded these two defenses. One of them is a lack of intent to meet. And that should be a defense, because if the defendant doesn't intend to meet with the person he's communicating with, then he doesn't have the intent to engage in illegal conduct.
I want to
What
ask,
about,
go ahead.
what about the fact that the state nevertheless has the burden to, under the statute, to prove specific intent, regardless of whether the defendant has that defense available to him?
So I think the best way to look at it is practically from the point of view of a record at trial. And the way that a record at trial would look is that the state would put on evidence of the specific intent, and then the defendant would get up and say, well, I didn't intend to meet. And the state would say, objection, relevance, because the statute says it's not a defense. And the trial judge would say, statute says it's not a defense. You can't testify to that. Objection is sustained. So the state would have to put on at least a prima facie case of solicitation, but then the defendant would not be able to bring in
Dispute that evidence.
Pardon?
Would not be able to dispute that evidence.
Wouldn't be able to dispute that evidence because of subsection D, 2, and 3. So I think that the best way to look at it is in mind of trying cases and of reading records, that the way the record would look is objection, subsection D2, subsection D3, sustained, because that's what the law says, and then the defendant can't offer that evidence. And then we would get to the end of the trial, and the jury would be instructed, and this court can take judicial notice of the jury instruction in the Maloney case. And that was the only jury instruction that I could think of that this court could take judicial notice of, because there isn't, we're pretrial here, we don't have a jury instruction. If you look at the jury instruction, that's what the jury sees. The jury sees that it's a crime to communicate, knowingly communicate, to solicit a child to meet with the intent that illegal conduct be engaged in. And then it says it is not a defense that the defendant didn't want to meet or that the defendant was engaged in fantasy at the time. So looked at from the perspective of the person who's actually going to be deciding the case, the jury, it's not a defense. So the defense lawyer gets up there and argues, look, he wasn't committing a crime. It was age play. It was fantasy. He never believed that this was an adult. He never intended to meet with a child.
Well, let's break this down.
Yes, sir.
We're talking about subpart C, right?
Yes.
A person commits an offense if the person over the internet, by email or text message or other electronic message system or through commercial online services knowingly solicits a minor to meet another person, including the actor, with the intent that the minor will engage in sexual contact, etc. And I guess, is your first argument here, this is not a conduct-based statute, this is a speech?
Conduct versus speech is really a red herring. There is no...
Well, that seemed to be a big deal in Lowe, because it determines how you look at the case, right? Because if it's speech-based, you looked at it differently, right?
No. That was dicta in Lowe, where Lowe talked about Maloney and said, oh, it's conduct-based, but really just narrow. Conduct can be expressive, and if conduct is expressive, it is protected in the same way that speech is protected. Okay. The courts have cited...
Now, but, I mean, you say it's a red herring, but conduct does seem to be somewhat important here, because here what we're talking about is not just somebody talking about sexual matters. We're talking about someone using a device, an electronic device, to communicate, no doubt, but importantly, to solicit somebody to do something, not just to talk about doing something, but actually soliciting them to do something.
Right.
So if we start out with that premise, don't we then, if it is a conduct-based statute, don't we then start out with the presumption of the validity of the statute?
No.
Okay, why not?
If it is a conduct-based statute that is content-based.
Because I thought the Court of Criminal Appeals said how we erred in Lowe, and I may be mistaken here, I thought what the CCA said about how we erred in Lowe was that we looked at it as a conduct-based statute, and therefore we started off on the wrong foot. We should have been looking at it as a speech issue, not a conduct issue.
So it's not a real distinction in First Amendment law, and it's confusing because there's a case there's a case called Broderick. Bear with me for a moment, Your Honor.
Sure.
A case called Broderick says that especially where conduct rather than speech is involved, the overbreadth must be substantial to invalidate the statute. Okay? So it looks as though, that Broderick case looks as though there might be a distinction between conduct and speech, but later Supreme Court cases have clarified that whether it's speech or expressive conduct, the same standard applies.
Here we are informed by our higher court, the CCA, and how they conducted their analysis. And it does seem to at least have been important to them to point out that we erred in starting off on the wrong foot that way.
We did err in starting off on the wrong foot, but the error was in not treating it as a content-based restriction on speech. And
Is this a content or conduct?
Content.
I know, but you consider this to be content or
It is,
conduct?
it is content-based, and it's content-based because of footnote 12 in Lowe. Footnote 12 in Lowe says if you have to look at what the communication was to decide if it violates the statute, then it's a content-based restriction on speech. And Lowe goes on to say if it's a content-based restriction on expression, speech broadly under the First Amendment includes conduct, burning the flag, burning the draft card. If it's content-based, then the presumption applies. It doesn't depend on whether the expression is conduct or pure speech. It depends on whether it's a content-based restriction or not.
So do you think the CCA got that wrong, or is that a flaw in their reasoning?
Let me take a look at exactly what they said there, Your Honor, because I have never read the CCA opinion to say that that 33.02, I don't even have it here.
Let me give you a perspective of how I'm thinking about this, and then you correct me where I'm going wrong.
Yes, sir.
The way I looked at Lowe was because Lowe involved the idea of using speech with a specific intent to arouse and gratify another, that made it appear to be conduct-based because you were trying to provoke a certain kind of conduct based on the speech. And in this case, you're talking about not just making a communication, but making a communication to get somebody to do something, to solicit a minor to do something, to meet another person.
Okay.
That is, both cases certainly involve conduct.
It doesn't matter whether it's conduct or speech. It doesn't matter whether I am waving the flag or saying the Pledge of Allegiance.
I understand you're saying that, but I thought the whole point of the CCA opinion in Lowe was that is an important distinction depending on because it starts out how you look at the statute. Am I mistaken about how they said that?
I think you're mistaken. I think there's dicta in Lowe talking about the statute that we have at issue here and mentioning probably in a footnote that it was conduct rather than speech. But it's really not a germane distinction under the First Amendment. And if you go further into Lowe, you see that what they're looking for is a content-based restriction. I see a question.
No.
Okay. So what they're looking for is a content-based restriction. And then if you look at their next case addressing a penal statute, which was Ex parte Thompson, they said the intent, that an intent is attached, could make it content, is one of the things that could make speech, in that case photography, which a lot of people would say, well, photography, that's conduct, that's not speech, but would make photography content-based. So in footnote 12 of Ex parte Lowe, the Court of Criminal Appeals said, if you have to look at the content of the communication to determine whether it violates the statute, it's content-based. If it's content-based, it's presumptively unconstitutional.
Well, I might agree with you to a certain level. I don't know if you're saying this, but it does seem to be that the CCA's reasoning was somewhat confusing because, of course, all these situations are going to involve speech. But, you can't solicit prostitution.
Right. And
I don't recall us ever looking at a solicitation of prostitution case as a free speech matter.
I don't know that any lawyer...
I don't know that anyone's ever challenged it that way.
But
yet we're treating solicitation of a minor to perform a sex act, meet another person and perform a sex act. We're treating that as a speech.
Right. So
part of my gripe is with how the CCA decided Lowe, obviously.
Okay, and I'll fix it this time.
Please do.
I will. But I've got it right now, and so I know in a way that I didn't know.
Well, you won, Lowe.
I didn't know, but here, at this level, I didn't appreciate, when we were briefing the Lowe case, I didn't really appreciate the the clarity of the Supreme Court case law on First Amendment matters. And now I do. And it is that a content-based statute is presumptively unconstitutional. Lowe made clear that if you have to look at the content, then it is content-based. So, okay, so the example of actual solicitation of a crime, that's the difference here. And Joan Huffman has introduced a bill in the Texas Senate. I don't know if you got my supplemental pleading.
Yeah, but the bill says that it's not going to be retroactive.
Right. The bill says that it's not going to be retroactive, but what the bill does is removes D2 and D3. Well, the Texas Senate didn't have to muck about with D2 and D3 if they were just trying to fix the problem caused by Lowe, because D2 and D3 only apply to subsection 33.021C. But you have to look at the content of the communication to decide whether it is solicitative. And what the Supreme Court has said is that, and there's the strict scrutiny argument, and then there's a categorical argument. I think the Supreme Court has turned to a categorical argument, but we win either way, strict scrutiny or categorical.
Well, what about the fact that you're not bringing an as-applied challenge, right? What you've asserted is a facial challenge, and that is an exceedingly high standard to meet. So address that, number one, but also, is it right, I have not seen in the record any indication that of what the indictment was here or any claim that Wheeler was actually engaged in age play?
I don't know, because it's not necessary to the overbreadth challenge. The first question in Austin on Lowe was, what are the facts of this case? And Judge Alcala responded with, whoa, it doesn't matter what the facts are of this case. For an overbreadth challenge, it doesn't matter. We're not saying that the statute is just unconstitutional as applied to Mr. Wheeler. We're saying it is unconstitutional as written. So to answer the other part—
in order to get there, though, don't you have to prove that it is— I mean, if a facial challenge involves showing it is unconstitutional as applied in every circumstance—
No, not in a First Amendment overbreadth challenge. In a First Amendment overbreadth challenge, the question is it content-based? If it is content-based, it is presumptively invalid. And then the question is, can the state overcome that presumption? No, it has to be overbroad in all cases is not the standard in First Amendment cases. That's in non-First
And
Amendment
what
cases.
authority says that?
U.S. v. Stevens, U.S. v. Alvarez, which are the U.S. Supreme Court's two most recent cases overturning penal speech-based statutes. Stevens was a crush video case where the defendants were making videos of animals being injured for people's gratification. And the Supreme Court said, no, that is not overbroad because this crush film video category is not a category that is recognized as unprotected. So, and to go back to Justice Jennings's question, if the future version of the statute were in effect, that statute would be constitutional. The reason that would be constitutional is because it actually requires solicitation. For the speech to be unprotected, it actually has to involve solicitation. And when you take out the fantasy defense and you take out the I didn't mean to meet defense and you take out the I didn't believe it was a child defense, then you cover a great swath of stuff that is not actual solicitation and is not unprotected.
Does this statute mirror just a normal solicitation of a minor?
No.
Except for it has the internet involved or the electronic devices involved?
No.
What's the difference between
the normal solicitation of a minor statute, the minor is somebody who is actually a child, or I believe whom the defendant believes to be a child.
So really, your whole argument here really is centered on D and how D relates to C?
Both A, the definition of minor, and D's relation to C, that we have to read it together. We can't read part of it out for the sake of trying to uphold the constitutionality of the statute. I feel like I missed something that you had asked me, Justice Huddle. I'm sorry.
I don't think so.
Okay. Well, thank you, and I'll get up and answer some more questions after the state has had their opportunity. Thank you.
May it please the Court. My name is Brandy Robinson, representing the state of Texas for the Appellee. The real issue presented here is whether the remainder of Texas Penal Code 33.021 should be upheld as constitutional when both the Court of Criminal Appeals and this court and the appellate court in Ex parte Zavala in San Antonio have all said that it is narrowly tailored to serve a compelling governmental interest. There are three main points which I think appellant has misread to some extent. First off, the strict scrutiny standard of review does not apply to this case, and because it does not apply, appellant has an exceptionally high burden of proof here. Second, the rational basis standard is the appropriate standard to review the case under, and under rational basis, the statute is constitutional. Third, even if strict scrutiny did apply, because the Texas Court of Criminal Appeals and this Court of Appeals and the other Court of Appeals in San Antonio have all said that it's narrowly tailored to serve a compelling governmental interest and that it's not impermissibly vague, it would survive under strict scrutiny even if that were the standard to be applied.
Why don't you elaborate on why you think that strict scrutiny doesn't apply?
The problem with appellant's argument is that he has fundamentally misread U.S. v. Alvarez and U.S. v. Stevens. They applied strict scrutiny in those cases. The categorical approach, the way that comes into play, is in determining whether strict scrutiny applies versus rational basis. And so you apply categorical approach first to see if the language is constitutionally protected, and strict scrutiny is only going to apply to a content-based restriction first on constitutionally protected speech. Those two requirements have to be met first, and then if those two requirements are met, then strict scrutiny would apply. So the categorical approach is important in determining that second prong as far as whether or not it's categorically protected constitutional speech or not. In this case, it's solicitation. That's what we're talking about. That's what subsection C prohibits, is solicitation. And the Supreme Court of the United States over and over again has ruled that solicitation, offers to engage in illegal transactions, are not protected. They're categorically unprotected by the Constitution.
Okay. But the way he's attacking this statute, as I understand it, is three ways. And I guess the primary way being how the statute defines minor. And the statute defines minor as an individual who represents himself or herself to be younger than 17 years of age, or an individual whom the actor believes to be younger than 17 years of age, rather than someone actually being younger than 17 years of age. And I guess that's his first attack, is on the definition. How do you respond to that attack?
Regarding the definition of minor...
And therefore he's saying, well, because of that, then you can't, then C doesn't really pass muster.
One thing that's kind of determinative here, as Justice Huddle has said, is that appellant has not only not shown how the age play defense applied to him, which this court in Maloney...
He's making an overbroad or overbreadth argument, so...
And he made the same argument in Maloney, and this court held in Maloney that he would still have to prove that it's facially unconstitutional, and it's unconstitutional as applied first to him and then unconstitutional to everybody else. But regarding the age play issue...
So is that right?
Yes, I think that is right. I think that in order to show that it's...
Is Maloney an outlier for employing that standard?
I'm sorry?
Is Maloney an outlier in that it applies that standard? It says you first have to show it's unconstitutional as to you and then to everybody else.
There's not been any negative history regarding that head note, that issue,
Do other
as far
cases
as I know
say the
of.
same thing?
I think that that's a consistent standard to apply, because in order to show that it's unconstitutional as to everybody, he has to also show it's unconstitutional as to him. But regarding the age play...
Before you move on to age play, I really want to narrow this thing down about the definition of what a minor is, because as counsel points out, in the regular solicitation of a minor statute, it defines a minor as we understand a minor, actually someone who is actually under 17 years of age. Isn't this an important distinction in this case about this definition?
It is an important distinction, but not for the way that appellant describes it. It's important because there's a difference between a person who is soliciting a child in person versus soliciting them on the internet. And a person who is soliciting a child just on the internet is going to bear the burden of responsibility for determining how old the person they're talking to really is. In person, that's easier to do because you're seeing the person.
What about Lowe, though? Because in Lowe, I mean, I read the headline in the Houston Chronicle, dirty talk to minors is to prohibit dirty talk to minors is unconstitutional. So if you have a constitutional First Amendment right, according to the Court of Criminal Appeals, to talk dirty to minors, what difference does it make if they're actually under 17 years of age or if they represent themselves to be under 17 years of age under Lowe?
It makes a difference here because solicitation is what's occurring, not talking dirty to minors. There's a difference because there's an offer to engage in an illegal transaction, which is constitutionally unprotected versus U.S. v. Williams. And so also, the court has to look at the legislative intent behind the statute in the first place, which was to make it a crime to solicit a child for sexual activity without having to prove that the appellant took that extra step of meeting the child or intending to meet the child after the fact. And that was the legislative intent there. And so in order to do that and to provide for the compelling governmental interest of protecting children before that child predator shows up on their doorstep, we have to allow for police officers to represent themselves to be minors to try and weed out this activity the same way that police officers would represent themselves to be a John looking for a prostitute in that type of case. So we have to account for that, and that's why the representation portion of the statute is important. One of the other things that appellant has discussed is subsection D and how it applies.
I have a particular question about that. Could you address Mr. Bennett's point about whether the specific intent requirement is effectively de facto lowered because you're going to prohibit a defendant from getting up and saying, I did not intend for this meeting to occur? Because that's the state's burden. It's a really high burden, and the defendant's entitled to get up and offer conflicting evidence or evidence to refute the intent element of the crime.
He is. And the intent evidence that under this statute he would still be allowed to offer is the intent that's required in subsection C. He can try to refute the intent required in that subsection.
How's that different from what's in D? It's the same thing, isn't it?
Zavala found that a reasonable construction is to find that subsection D2 actually applies to the intent after the fact. I kind of refer to it as the cold feet subsection.
The change of heart defense.
A change of heart defense. And so under the statute as it stands, a defendant would not be able...
Isn't that encapsulated in the D provision that says it's not a defense that the meeting didn't occur? I mean, that's the change of heart defense, isn't it?
Right. And if the court applies strict scrutiny, it's possible that subsection D could be thrown out because the legislature has to use the least restrictive means possible if we're applying a strict scrutiny standard. If we're applying the rational basis standard, however, then any reasonable construction will support finding the constitutionality of the statute. And subsection D2, Zavala Court has already found that there's a reasonable construction that it applies after the offense. And the Texas Court of Criminal Appeals refused the petition for discretionary review on this case, which kind of indicates where they fall. Yes, in Zavala. That kind of indicates where they're going to stand on this vagueness issue. And I think that it's a reasonable construction that subsection D2 applies after the fact. And but if the court did apply strict scrutiny, then subsection D2 may not survive. If that's the case, appellant is asking the court to throw out the entirety of subsection C, the entirety of the online solicitation of a minor statute, just based on one subsection regarding one defense that he feels can be read inconsistently with the rest of the statute. And the court's not required to do that. Under Tussey v. State, which is cited at 494 Southwest 2nd, 866, the Texas Court of Criminal Appeals has said that if you're reading a statute and one subsection is inconsistent with the rest of the subsections and one subsection is unconstitutional facially, the court can throw out or strike out that one subsection.
Is there any idea why the legislature used this language, the actor did not intend for the meeting to occur in D?
Yes, the legislative intent behind the statute and the analysis when the statute was written, from the very start, they wanted to lower the state's burden from the actual solicitation of a child in person standard, because in a regular solicitation situation, the offender and the child would have to meet. There'd have to be some, or the offender would have to show up to meet. There'd have to be some additional preparation act. And the legislature...
Did the legislature mean to say the act, regardless of whether the meeting occurred?
Yes.
Is that what they meant to say?
I think that that's from the very start. Subsection D1 and D2 were in the very initial draft of the bill, and they said that they intended those sections, or not those sections specifically, they didn't list those sections specifically, but they said that they intended this statute to apply so that the state would not have to prove that the defendant showed up for a meeting or intended that meeting to occur.
Well, there's a difference between whether or not the meeting actually occurred versus whether the defendant intended for the meeting to occur. There's a big difference, right?
There is, yes.
Okay. Do you have any idea how they went further and added this do not intend? Is there any reason?
There's no specific language regarding why they added that. It's just clear that from the very start that they had those two together. And then when they added subsection 3, they specified subsection 3 applies at the time of the commission of the offense, which implies that subsection D1 and D2 are not meant to apply at the time of the commission of the offense. Now, when appellant is talking about the representation, as I described earlier, that's necessary to help the law enforcement purpose of preventing these offenders from showing up on a child's doorstep. The other issue that appellant has talked about regarding overbreadth is the fantasy language, that the fantasy language it creates a prohibition on lawful fantasy. That's just not accurate. The fantasy language doesn't create a prohibition or prescribe fantasy. Instead, that fantasy language just says fantasy is not a defense, which almost could even be considered surplusage, because fantasy is never a defense in criminal cases. The only time it would be a defense is in an insanity type situation. If a rapist walks into a woman's house and intends to sexually assault her and then later says, well, I fantasized that she was a willing participant, that's not going to be a defense. Likewise here, the fact that a defendant is engaging in a fantasy that this is okay behavior to engage in, or any kind of fantasy at the time that he's doing it, is not going to change the elements that the offender has committed, that he's broken the law by committing this solicitation of a minor. Appellant talked about why strict scrutiny applies, and I'd like to jump back into why it doesn't apply here, if that's okay with the court. That first off, this is a conduct-based...
Before you do that, does it matter how we start out looking at this as versus conduct versus content?
It does, and Lowe made that exceptionally clear, and in fact, the actual language from Lowe is on page 16 and 17 in the Lowe opinion. It said that such solicitation statutes, it's referring to subsection C, exist in virtually all states and have been routinely upheld as constitutional because offers to engage in illegal transactions are categorically excluded from First Amendment protection. And then it goes on to say, thus it is the conduct of requesting a minor to engage in illegal sexual acts that is the gravamen of the offense. Now, appellant makes a big deal in his brief about incitement and how we have to prove that this was incitement. That's not true, because solicitation in its own right is unprotected. It's categorically unprotected. And also, solicitation is language that's integral to criminal conduct. In other words, the criminal conduct can't occur without this language. That's just part of the criminal conduct. They're inextricably tied together. And so, I would have argued that this court was right in Lowe, but right. I would still say that this is a conduct-based offense, and the Court of Criminal Appeals agreed.
Well, doesn't the holding of Lowe and how they got to their decision in Lowe, isn't that also problematic somewhat here? Because, in Lowe, we were focused on the conduct of using a electronic device to communicate with somebody, not just to, provide educational materials or anything like that, but to actually arouse and gratify, which to me seemed to track the public lewdness statute. What makes public lewdness wrong is that with the intent to arouse and gratify another.
Right.
The CCA obviously didn't buy into that reasoning and rejected it, saying, no, this is more content. Is that right?
That is correct. That's where they went. I think that's not necessarily problematic here. For one thing, because there's this great weight of cases regarding solicitation and all.
Well, here may be a distinction, because if you think about who is a minor, right? It's not illegal to solicit, for one adult to solicit another adult to meet another person to have sex. If there's an exchange of money, there is.
Sure.
But there is nothing illegal about an adult contacting and soliciting another adult to meet another person and have sex with that person, have sexual relations. And I think that's part of, seems to me, what Mr. Bennett is arguing, because of how this statute defines a minor. Now the adult police officer, who is not a minor but who's saying he's a minor, is trying to set up such a meeting, then it becomes more outside the realm of conduct, as we've been talking about solicitation, because the conduct is the solicitation, right? And if the solicitation is otherwise normally legal, now this statute has, in Mr. Bennett's, if you buy his argument, this statute has basically over broadly defined something to be illegal, which is really not illegal.
I think.
Does that make any sense?
It does. I think, and correct me if I get.
And if you buy the reasoning of Lowe and the CCA, it might be problematic here.
Well, and for one thing, I think Lowe pretty much didn't have to get into C, and they got into C, I think, specifically to give the court's guidance that they thought C was okay. So I'm not exceptionally concerned about the Court of Criminal Appeals suddenly just completely changing their mind on that.
I wasn't concerned about them very much in Lowe, but
fair
they
enough.
reversed us 9-0.
But I think that the key distinction here, the difference, is going to be the compelling governmental interest. And for Lowe, they had this concern that there's this massive amount of sexually explicit material that's not illegal that could be covered here. Appellant has a burden here to show that that this is actually being abused, that there's a potential for widespread abuse. This statute's been in play for almost 10 years, and appellant hasn't provided the court a single case where two innocent adults have been engaging in innocent contact where one is pretending to be another. But also, I think that it's a fact question for the jury.
Well, I mean, you use the words two innocent adults. I mean, I bet you he could cite you examples of where the adult defendant has been in contact with an adult purporting to be, and that's his point.
But I think that the situation really is what it comes down to when you look at represents. It's going to be a fact question for the jurors to determine whether or not someone has truly represented themselves to be a child. Because in the appellant's argument, he's describing a situation where two people who have confirmed that they're adults, confirmed that they're consenting, then agree that one of them will pretend to be a child. And I think in that circumstance, that defendant would be able to argue, probably successfully so, in front of the jury that he didn't really represent himself.
What's wrong with making it illegal for someone to knowingly solicit a minor to meet another person to engage in sex and misrepresent themselves as being a minor? What's wrong with making that illegal?
I'm sorry, I'm not sure I understand the question.
We're approaching this problem as if, and I know Mr. Bennett's approaching the problem as if, well, focusing on the definition of minor, who represents himself to be a minor. What's wrong with making it illegal for someone to represent themselves as a minor and then, solicit sex?
A person representing themselves to be a minor and then soliciting the adult
What's
for
wrong
sex?
with making it illegal for someone to misrepresent themselves as a minor?
I think the court... I think that the legislature could do that to make it illegal for someone to misrepresent themselves to be a minor on the internet. But I also don't think this statute poses an unreasonable burden on people using the internet, because it's a similar burden that we face in statutory rape type cases, that the adult...
If you're not sure, don't do it.
Exactly. If the adult person in that situation has a responsibility, a legal responsibility, to make sure that the person they're dealing with is legally able to engage in that activity. And that's all the representation requirement requires, is that if, and this court saw that fact pattern in Maloney, where, 47-year-old defendant is trying to get after the officer had only represented himself as a 13-year-old girl. In every single communication they had, and with a photograph and everything, represented himself as a 13-year-old girl. The state shouldn't have an added burden of proof to prove the defendant's subjective state of mind at that time regarding whether or not that child is a 13-year-old girl. The defendant bears a responsibility. If somebody has done nothing but represent themselves to be a child, the defendant bears the responsibility not to solicit that person. And that's not an unreasonable restriction to place on people using the internet. I think that's reasonable, considering they don't have the type of clues that they can use in real-life interactions that we use to determine someone's age.
And so your point as a practical matter is that if you involved in an age play scenario, you will be on some sort of site where, as a condition to entry, you have represented that you are in fact an adult and not a minor. And then once you make that representation, you go on to engage in a fantasy regarding being a minor.
Right. And I wouldn't recommend the court go to any of the sites that are listed in counsel's brief, but those sites all have terms of conditions that say you have to be 18 to enter. That's a standard condition for any kind of site that has this, sexually explicit material type age play or fetish play. So again, you have people who have represented themselves to be adults and then agreed that one of them is going to pretend to be a child. And as this court cited People v. Smith, which was the Illinois solicitation statute. In that case, they said the potential for law enforcement abuse here is exceedingly rare, because police officers aren't going to these adult fetish websites to look for these child predators. Police officers are going where children congregate on the internet and pretending to be children, because that's where the child predators are. And that's one of the things why representation becomes important, and why it's an important part of the statute to protect real children from being victimized.
Thank you.
Thank you, Your Honor.
There is a quote in U.S. v. Stevens that may be in my brief, which is something to the effect of, we don't depend on the government exercising its discretion to make a statute valid. So the argument that we wouldn't do that holds no weight whatsoever in First Amendment law. We look at what could be done rather than what would be done. And this is another area where Maloney slipped a little bit. Maloney said we have no reason to believe that there would be a substantial number of prosecutions of protected speech. The question is, could there be? And the state has the burden to show that there could not be, because, and I looked at Lowe again, Justice Jennings, because I was puzzled on why we understood it differently. And the second paragraph says, because the Court of Appeals used the wrong standard of review for addressing constitutional challenges to a penal statute that restricts speech based on its content, it reached the wrong conclusion. I think perhaps...
Yeah, that's where I was coming from when I was asking my questions.
Perhaps you focused on speech, whereas the focus should be on content. That either conduct, waving the flag, burning the draft card, or actual speech, if the restriction is content-based, then it is presumptively invalid. I would love to see the state's case supporting the proposition that rational basis applies, because I've read the state's brief and I've looked at every case. There is no authority presented for the proposition that the courts use a rational basis standard of review if the statute punishes conduct instead of speech. And then in the following sentence, they cite Lowe and Broderick for that proposition. Neither of them stands for that proposition. I would contend that the state is inventing this rational basis application out of whole cloth. With all due respect, if there were some case saying that a rational basis test applies to a content-based restriction on conduct, if we call it that, I think it would be in the state's brief. There actually was a case that I litigated in which the state had prosecuted a guy who tried to claim at trial that he knew that he was communicating with an adult. It was a perverted justice case. The woman testified that here's the transcript of our conversations, and the defendant, I got the case in post-trial litigation, the defendant tried to testify, I knew that this was actually an adult because of stuff that happened before the transcript began, that the transcript had been edited by perverted justice. And he wasn't allowed to testify to that. His lawyer wasn't allowed to argue that. In jury selection, the jury had real problems with that, but that's why he got convicted. This was Randy Jennings, Thomas Randall Jennings. It's in the 14th Court of Appeals. I don't know that this court can take judicial notice of the record in that case, but perhaps it can. It's a sister court in the same building. And if it can, I would suggest that the court take a look at that record for a concrete example of a guy who was convicted based on what the state says would never happen.
Let's see if you can boil this down for me. I mean, I understand, I think, your point about D 2 and 3, and the legislature is going to take that out. As far as we know, I mean, there's at least a bill to take that out.
And that'll correct the problem.
That'll correct that part of the problem. But you still have a gripe with how they define a minor.
And they're fixing that as well in Senate Bill 344.
Okay, but we still have to deal with this statute as it applies to this particular defendant, or this statute in regard to this defendant, and they're saying that bill's not going to be retroactive.
True.
So you're still attacking this based on the overbreadth of D 2 and 3 and the definition of a minor under A1.
Yes, and the state says there's a plethora of other statutes that criminalize the same thing. They don't. There's not a single other statute.
Well, let's just focus on that definition of a minor.
Yes, Your Honor.
What's wrong with, as the state argues in this case, of defining a minor as one who represents himself or herself to be younger than 17 years of age, or an individual whom the actor believes to be younger than 17 years of age? The state argues, why not let the legislature put the burden on the actor to determine whether or not this person really is younger than 17 years of age or not? And
I'll use the example of the age play site where everybody signs the conditions promising to be at least 18. If a person goes on such an age play site and says, hey, let's play, I'm a 15-year-old cheerleader, and another dude says, I'm a 16-year-old star quarterback. Each of them has represented himself to be a minor. They didn't when they signed the conditions, but they represented themselves to be minors, and the state thinks, oh, that's not representation. You bet that's representation to be minor. If I say right here, I am 15 years old, I'm representing myself to be 15 years old. It's not true.
But if this were another, let's say this were a fraud case, and you were, and I don't know how to come up with a better example, but if this were like a fraud case where someone says, this isn't Elvis Presley's guitar.
Okay.
But if you give me, $50, I'll play with you and we'll pretend it's Elvis Presley's guitar.
Okay.
There's really not a misrepresentation there, is there? Because the individual has said up front, this really isn't his guitar, but wink, wink, we're going to play like it is. Isn't that the same thing that's occurring on these fantasy websites? People are going on and clicking, I am 18 years of age or older, and then they get on and they act like they're not.
It is. There is no misrepresentation, but the statute doesn't say anything about misrepresentation. It's simply a representation. So even if I pay you $50 to claim that this is Elvis Presley's guitar, and you get up on stage and you say, this is Elvis Presley's guitar, you're acting, you're improvising, you're performing at the Opry for money, and everybody knows it's not true, you're Minnie Pearl and you're joking about it, you're still representing it to be the case.
But in that case, the person standing in the shoes of your client, the actor, really wouldn't believe.
Right. Right, yes. My client wouldn't believe that it was Elvis Presley's guitar, and that's why the legislature...
But because he had exercised some kind of diligence, he would know he shouldn't really believe it.
Right. Yes, exactly. And he could be prosecuted for buying Elvis Presley's guitar because Elvis Presley's guitar is defined as a guitar that is represented as being Elvis Presley's. If you tell me,
No, it's not. Yeah.
even though you've represented it not to be at one point and then you've represented it to be at another point, well, you still have represented it to be. There's no magical representation happens only once clause in this law. If I say that something is true, I represent it to be true. Even if you know differently, even if the whole world knows differently, I am Jimmy Buffett. Ladies and gentlemen, I am Jimmy Buffett, and I'm going to sing and dance for you because I'm tired of being a lawyer. By the way, that's the only job that I can think of that I'd rather have than what I'm doing here today. So if I tell you I'm Jimmy Buffett, I'm representing myself to be Jimmy Buffett, even though we all know it's not true. I can't sing worth a lick. Thank you very much. I do appreciate your time, and I've enjoyed talking to you today. And if there are issues that you'd like supplemental briefing on, I'm sure the state and I would be happy to provide you more written information.
Thank you. Case number 0114000868-CR ex parte Stuart Wheeler is now submitted. Y'all are excused.
Thank you very much.
We'll give counsel in the other case a few moments to get set up. Okay, 15, 15, 5, and 5. This is what I picked up.
Okay.
Please the court. Your Honor, is Levon Hovenatanian representing the appellant Cross Appellee United Services Automobile Association. I resisted the temptation to call Ms. Hogan today and ask her if she would join me in filing a motion to move this oral argument outdoors, because this is truly a beautiful day. It's almost a shame.
We had that same discussion back in the road.
I bet. It's
We
almost
did.
a shame to be here, but I'm sure she would agree with me that if we're going to be indoors, this is what we'd like to be doing indoors.
If you would like to go out and sit on the lawn, that's fine with us.
That's awfully tempting, Justice Higley. It really is. This court in Oyster Creek in 2004 laid down the requirements of excessive demand, and it's a broad requirement, and the court's exact language is the dispositive question in determining whether a demand is excessive is whether the claimant acted unreasonably or in bad faith. So that's the standard. Is when we look at excessive demand in this case, did the Hayes act unreasonably or in bad faith? Now, since Oyster Creek in 2004, other courts have added, sort of engrafted one other requirement on the excessive demand defense, probably best exemplified by the Barnes case out of Dallas in 2011, where the court said this defense will only apply where the creditor has refused the debtor's tender of the correct amount due.
Correct me if I'm wrong, but my understanding is most of the cases you're talking about, there's like a specific amount due and owing at a specific time.
I think that's correct, Your Honor.
And what is your best authority that this same kind of reasoning would apply to a demand for attorney's fee situation? This isn't a creditor-debtor deal where
True.
there's a specific amount owing, but it seems like all your authorities pointing in that direction.
Well, and I guess I'll respond with two cases. The first one is McMillan, which was decided, McMillan versus State Farm, where the court in 2012, the Austin court applied excessive demand to a homeowner's insurance case like this one. The other case...
Did they apply it to attorney's fees?
Your Honor, I'm not certain, actually, if it was in attorney's fees. That's why my second case...
Because most of them, my understanding is there's an amount due and owing. There's a specific amount due and owing.
Right. Well, McAllister answers that. McAllister is a case where the letter said, this letter shall serve as a demand that you make arrangements to pay the full amount of $192,000 plus attorney's fees of $2,500, et cetera, et cetera. That's an excessive demand case where the court said we're dealing with not only a claim of actual damages, but a claim of attorney's fees, a specific claim of attorney's fees like the one in this case. So I think I hang my hat on a combination of those two cases. Okay. It does.
Where is that case out of? What court?
Your Honor, McAllister was decided by the Fort Worth Court of Appeals in 2012.
So those are your two best authorities?
Those are correct.
And neither one of them really deals with an attorney's fee situation?
Well, McAllister does, Your Honor.
Okay.
Expressly.
Explain that to me again.
And I apologize.
How's that on all four squares with this case?
Well, because the letter in McAllister makes a demand for a specific amount of attorney's fees, just like the letter in this case.
Okay.
McAllister says, this letter shall serve as a demand that you make arrangements to pay the full amount of $192,000 plus attorney's fees of $2,500 for handling this matter within 30 days of this letter. And then it goes on from there.
And plus $2,500 for attorney's fees?
Correct.
And in that case, they said that the $2,500 for the attorney's fees was an excessive demand?
They did not. They found the opposite. In that case, the court, well, no, I beg your pardon. They didn't find the opposite. The court held this is an excessive demand.
It is not?
It is. It is an excessive demand.
$192,000 was an excessive
The total.
Together.
Correct. And that's where I don't want to mislead the court. The McAllister court didn't say it's the $2,500 that's the tipping point. That's what makes it excessive. The court considered the amounts together and said this is an excessive demand.
Okay, but it wasn't specifically about the $2,500 in attorney.
That is correct. The $2,500 went into the kitty, so to speak, along with the $192 and everything else.
Let's see if you can walk me through this.
Sure.
Because here you had a jury finding of a specific amount for attorney's fees.
Correct.
After all was said and done. What was
Correct.
that amount again?
Your Honor, if we're talking about appellate, I'm sorry.
No, just the jury's finding on the...
Well, they broke it down. They said $237,500 for trial.
$237,500 for
Correct.
the trial.
And then $50,000 for the Court of Appeals, and then $25,000 for the first stage of the Supreme Court, $25,000 for the second.
And the demand for attorney's fees, the initial demand for attorney's fees was how much?
Well, $248,667.24. But to be fair, that was for expenses including attorney's fees.
That was the demand that the plaintiffs made for
Correct.
attorney's fees.
Correct.
So you really only have a difference of $11,000.
For attorney's fees, and what was awarded and what was demanded, that is correct. But of course, it's not just attorney's fees. It's also the other components of the letter were mental anguish damages and actual damages.
Okay, well, the trial court took away attorney's fees.
Correct.
And that seems to be where you're focusing on your argument, is the trial court did not err in taking away the attorney's fees.
Absolutely right.
And the trial court took away the attorney's fees because the trial court agreed with your argument that because the initial demand letter for attorney's fees, at the point in time it was made, there's no way that any such attorney's fees could have been incurred.
Well, Your Honor, I think respectfully, to be a little more precise, I think Judge Ray considered it in toto. She looked at not just the attorney's fees, but also the mental anguish claim and the actual damages claim, and considered the whole $621,000.
But the jury awarded $237,500.
For trial, correct.
Trial court entered a JNOV and changed that to 0.
Correct.
And it did that because it must have believed as a matter of law the plaintiffs were not entitled to recover attorney's fees because they made an excessive demand.
That's correct. I wish I had stated it that clearly. That's absolutely correct.
Okay.
Judge Ray determined that USAA had conclusively established its excessive demand defense. They had proved it as a matter of law.
Okay, now, walk me through that. How did y'all conclusively establish that fact to where the trial court had no choice but as a matter of law to enter a zero finding?
Well, it starts with the demand itself. And the demand in this case is the October 1st, 2009 letter, the terms of which we've been discussing. So first, I think what Judge Ray did was she said, what's the demand? The demand is not, for instance, Mr. Hayes telling inspectors hired by USAA, I want a new roof. I'm mad because I don't have a new roof. I believe Judge Ray concluded, and the Hayes didn't argue anything contrary below, that that is not the demand that we're talking about. What we're talking about is the notice letter where the Hayes state, you owe me A for B and C for D and E for F, and went on to make the terms of what the court, I think, would consider a traditional demand letter. So it starts with that. That's the playing field we're on, is that letter. And then the court said in Oyster Creek that when the demand is greater than the amount that's awarded, and in this case it's greater than both what the jury awarded and what the judgment awarded, then that is some evidence of excessive demand. Doesn't establish it as a matter of law, and we're not saying the contrary. But the court said, this court said, that's some evidence. So we start with those points in Judge Ray's favor.
Well, so how do we get from some evidence supporting an excessive demand to conclusively this was an excessive demand to where the plaintiffs don't get their attorney's fees, which under the statute they would normally get?
Right. Well, at this stage of the proceeding, the only answer to that question is you look at what they proved and you look at what they demanded. And that's what Judge Ray did. For example, $50,000 was the demand for mental anguish damages in the October 1st, 2009 letter. At trial...
Not just attorney's fees.
Correct.
Even though that's all she took away on this issue of excessive demand.
On this issue, you're correct, Your Honor. That's exactly right.
All she took away on the issue of excessive demand in the JNOV was attorney's fees.
Right. That's the only remedy as far as the defense of excessive demand is the other side, the prevailing side, doesn't get their attorney's fees.
And that's the single remedy under excessive demand.
That's
law.
correct.
Yes.
That's correct. That's correct. But in looking at the components of the notice letter, for instance, the Hayes said, we demand, their word, $50,000 for mental anguish damages. Well, at trial, what Judge Ray had in front of her was literally no evidence of mental anguish damages. The record is so empty has such a lack of evidence on mental anguish, the Hayes didn't even request a jury submission on it.
So walk me step by step here. So $50,000 was demanded for mental anguish.
Correct.
And they presented zero evidence on mental anguish.
Correct.
Okay. What else you got?
Well, we discussed the attorney's fees.
Right.
And that leaves the economic damages.
But as far as the jury found $237,500 in attorney's fees.
Correct.
You didn't say there's no evidence of no evidence of reasonable and necessary attorney's fees. Your argument was excessive demand.
Well, we have other arguments, Your Honor, attacking the attorney's fees, but essentially, you're correct.
Are you saying they presented zero evidence of reasonable and you're not saying they presented zero evidence of reasonable and necessary attorney's fees?
We are not saying, we are not saying that, well, yes, the answer to your question is yes.
Okay.
We're not saying that.
Okay. So attorney's fees, mental anguish, and what else was excessive?
Economic damages. The letter claims $323,000.86 in economic damages. If you took what the Hayes proved at trial, if you took, for instance, their own version of what USAA owed for their roof, their invoice, their evidence, that $323,000 would pay for 28 new roofs. That $323,000 would buy 2 more houses like the one we're talking about that was valued at $144,000. And so that's pretty good evidence right there that $323,000 in economic damages is excessive and outrageous.
And the jury only found what, like 20-something?
20, correct. Correct. And Your Honor, if it actually gets worse from there, because if you parse it by the two claims in this case, and by that I mean interior and exterior, if you start with the exterior, the Hayes proved $18,000 of economic damages to the exterior to their house. USAA had already paid $14,000, and what was left was approximately $3,800. If you look at the interior of the house, the Hayes proved $34,000. USAA had already paid $11,000, and there was $5,000 in the 34 for the carpet that could not be attributed to Ike. And so that left a total of $13,000 for the interior. So if you add the interior and the exterior together, the Hayes proved a little bit more than $17,000 in repairs. 5% of the economic damages they claimed in their demand letter. 5%. That, we respectfully contend, is excessive and outrageous as a matter of law.
Well,
And-
I have a thought I'd like for you to address for a second.
Please.
You have framed this as a matter of law issue.
Yes, Your Honor.
But the trial judge, her judgment, which she called it, is a finding.
Correct.
Why isn't this, or why isn't the correct way to frame this as sort of an agreement to submit this fact issue to the court, because there was debate about whether it should be submitted to the jury? I mean, that's not what you're arguing, I think. You're saying this isn't a fact finding.
It is not a fact finding, correct? It is not. It uses the word finding, absolutely. But the answer to your question is in the Brown case from 2002 from Texarkana, where the court said it's not a finding of fact, but a statement of ultimate fact when a fact is stated in the judgment and used as the basis for the trial court's conclusion. The court said, don't get caught up in the semantics. It says finding, but it's an ultimate finding, not a finding of fact as we would traditionally think of it, like findings of fact and conclusions of law. In order for the court to determine that USAA conclusively established its excessive demand defense, the court has to conclude, that this is an excessive demand. That's all that's saying. And
Right, but there's a difference between concluding that as a matter of law.
Correct.
And concluding that as a fact finder who hears some evidence going each way.
correct. And to be fair, the court absolutely determined this. This is sort of the Cliff's Notes version, but USAA wanted to submit it to the jury. The Hayes came in and filed.
They don't want their settlement offer.
Correct, correct. And the bottom line is that they argued and the judge went with it. This is something that the judge should figure out. In fact, there's even a part of the record where I believe it's Mr. Cacciola says this is a question for the court. It's not a question for the jury. And Mr. Martin for USAA said something similar. In fact, that's, if you look, Your Honor, in Volume 8 of the reporter's record, it's pages 248 to 249, where Mr. Martin for USAA and Mr. Cacciola for the Hayes are agreeing. And at one point, Mr. Cacciola says, that's a decision for the court after the jury comes back with the verdict. Judge Ray wound up agreeing and took it upon herself to decide the issue with both parties really telling her you can do this and you should do this. Correspondingly, she also agreed with the Hayes to keep the letter out of evidence. And so no argument and no evidence was permitted on the letter before the jury.
Did 15 minutes go by?
It seemed like 5, but it sure did, Your Honor.
You didn't talk about shingles.
No, that's not nearly as interesting as excessive demand, in my humble opinion.
I guess we can hear about shingles in your 5-minute rebuttal.
Sure. Thank you, Your Honor.
Thank you.
May it please the court. I will devote most of my argument, I think, to the attorney's fees question, in which we are the appellant in this case. The trial judge took away the attorney's fees in response to a motion for judgment notwithstanding the verdict. And the argument that was presented to the judge in that motion for judgment notwithstanding the verdict was that USAA had conclusively established its defense of excessive demand. And that is what the court did. I would disagree with the suggestion that this case was ever, that in this case it was ever agreed that the trial court was going to get to determine the excessive demand defense in some sort of a bench trial after the case was concluded and was submitted to the jury. We have set out in our reply brief, and I'm happy to kind of walk the court through it, but it's in our reply brief about sort of what these arguments were on each side of what was being argued that the court ought to determine, and what we were arguing was a question of law, what the other side was arguing should be a fact question. But I think it is very clear, and I think you heard Mr. Hovnatanian agree, that the way this got resolved was on a motion for judgment notwithstanding the verdict, and because the court concluded as a matter of law that this defense was conclusively established.
Is this a legitimate defense in this case?
Well, Your Honor, it is. We certainly have argued below, and that was the first reason why, so we divided this into two pieces, this common law excessive demand defense, and we made the argument below consistently in front of the judge that this case is not a case in which this defense ought to apply. And that's why we then said that's a matter of law question for this court to determine. There's nothing for the jury to hear.
So why shouldn't it apply?
Well, and what I've done here in our briefs in this court is, frankly, because of the posture that it's in, I'm willing to accept that it can apply to unliquidated demands, and this was an unliquidated demand. Because I think that it is there is just no doubt in my mind and in this record that this defense is not conclusively established as a matter of law.
Well, let me ask you to pause there. I mean, are you conceding that this is a legitimate defense in this case? Or are you, I understand your point being, hey, I don't care because I win anyway.
Right. No, I am not going to concede that it applies to unliquidated demands, because I think that there are certainly cases out there.
What about the specific case he discussed in his argument, McAllister? How do you distinguish that and say, well, yeah, that's all well and good in McAllister, but it doesn't apply here?
Well, there are many reasons that I would distinguish McAllister, but on the specific issue of does McAllister apply the excessive demand defense to an unliquidated demand, it does, and other courts have. This court has not specifically said that it applies to an unliquidated demand. But I'm not. But
the Supreme Court hasn't done this.
No, the Supreme Court's opinion in the case basically says we're not going to say that it does not, but we have no reason to go there. So that's where we are.
Other courts have gone there, but we haven't.
But I really do not want that. I mean, I'm not asking this court to come out and say that because it's an unliquidated demand, it doesn't apply.
We could write an opinion saying, regardless of whether it applies or not, the trial court erred in ruling as a matter of law.
Yes. And the trial court erred as a matter of law. First of all, this court's standard Constructors versus Chevron case. I mean, the notion that it is enough for the trial court after the verdict has come in to say, okay, I see there is a demand letter out there that demands whatever, $500,000, and during the jury trial, you put on evidence and ask the jury only for $90,000. Those are the facts of this court's decision in Standard Constructors versus Chevron Chemical, cited in our brief, and I can give you the cite if you'd like, but it's in the briefs. In that case, there was a demand for $500 and something thousand. Undisputed that demand was made. The only evidence at trial that was put on and all that was recovered was for $90,000. And this court said that that standing alone does not conclusively establish an excessive demand. You cannot simply, after the fact, and there is no court that's going to say that all we're going to look at are those two things, and that is enough to conclusively establish an excessive demand. And we get to look at the evidence from our side. And what we have also is this notice letter, and I want to kind of walk through that. I've given the court, it's taken straight from the record, but I've passed it out to the court as an oral argument exhibit, and I will walk through that and why that letter cannot conclusively establish. But all of these cases, including the cases that are cited by USAA in its briefs, recognize that in order to establish an excessive demand defense, you must have the evidence, and in our case you must have conclusive evidence, that the person sending the demand, so the creditor, or the debtor, I guess. I'm going to get confused here. In our circumstances, that the plaintiffs either specifically refused a tender of the actual amount that was owed, or clearly indicated that they would refuse a tender of the amount owed. So that's what USAA has to conclusively establish. Even the cases that they cite
Focus is
recognize
on the tender, not what was.
That's right.
Not
Whether
was
or not
offered.
exactly whether or not because no matter what we demanded, if they did not make us an offer, or we did not clearly indicate that we would refuse an offer, and that's not conclusively established, then the excessive demand defense is not conclusively established. And they do not have conclusive evidence that we would have refused a tender of the amount due. There is nothing, in the record that exists before you, there is no such evidence. The only evidence that they have argued in their brief that supports that is, in fact, this notice letter. And so I would walk the court through the notice letter.
Is that what you gave us before?
Pardon me?
Is that what you gave us today?
Yes, that's what I gave you today. It is pulled from the record. It's in several places in the reporter's record. This is pages, as they say at the bottom, the clerk's record, 26, 27, and 28. So this is where these amounts are stated. And first I would suggest to the court, the idea that the amounts that we have here, the reason why I think liquidated versus unliquidated demand comes in also is that this letter is written not simply as a letter to say what you owe me under the contract is X. This letter is written as what you owe me, what we are demanding in the first instance, be at the time we're serving our petition, before any discovery, without a claim file. We're going through and demanding these amounts, and in the spirit of compromise, but the numbers that are out here are not just for the contract claim, but also for breaches of the insurance code. And we point out that those breaches can lead to treble damages. We point out that there's an 18% penalty that's involved. So that explains how it is that we're coming up with the numbers from the initial standpoint. And we open, and so that's the first things that I've highlighted for you on page 26, the first page of the letter, that we've made a claim against the insurance policy. And what we say is, to date, we have yet to receive full payment under the insurance policy. And that's not a demand. That's the last sentence of the first paragraph. And that's not a demand for any amount of money, but just identifying that we have not received everything we're entitled to under the insurance policy to date. The jury agreed with us on that. So did the trial court. She entered judgment on those amounts for us. Then we say that undoubtedly you're aware that your liability to my clients under the Texas Insurance Code. And we go forward and set out 7 different ways in which we say that they have violated the insurance code. And then we say that furthermore, the delay in payment is also in violation, that we're entitled to an 18% penalty. And after all of that, we say, accordingly, on behalf of Joseph Hayes and Joanne Hayes, we're demanding these sums of monies. Demand is hereby made that within 60 days, the following amounts be paid. And we list off these amounts. We immediately follow that with the information that this demand is made in the spirit of compromise. According to our analysis, the demand represents a tremendous savings, giving the potential exposure under the Texas Insurance Code. Thus, we hope this is viewed as a good faith and conservative effort on our part to expeditiously resolve the potential litigation on amicable terms. Then we say if it's not paid within 60 days, we would expect to recover. So this is then when we say if it's not paid, here's what we're going to do. We're going to go to trial. And that we also can have treble damages, et cetera. And then we say that we're anxious to have the matter resolved promptly. We hope that you will immediately respond in writing, not that you pay us again, but that you respond in writing. If you have any questions, then please feel to contact us. Thank you for your attention to this matter. There is certainly a fact issue within this notice letter giving the inferences our way that there is at least some evidence here that we were not making a take it or leave it offer, and that there was room for negotiation, and that we would consider the amount that was due. And given that that sort of fact issue exists, the trial court was not in a position to rule as a matter of law on the excessive demand defense. Mr. Hayes testified at trial that he did not demand $250,000 in advance at the time that he filed his lawsuit for payment of damages to his house. He denied even knowing about this letter. He testified that he went to, and that's corroborated in their own records, that after they were offering, USAA is paying him just to reseal these shingles. He went to them one last time after he had talked to a lawyer, and he went back to them after having talked to the lawyer, told them, I've talked to a lawyer, I want you to pay to replace my roof. That's all he wanted, was for them to pay to replace his roof. That was not a demand, and the court, again, does not get to simply ignore that evidence that is favorable to our side and pick out and say, okay, well, nope, we're not going to look at anything. We're going to exclusively look at this one demand letter that's not even before the jury, and we're going to exclude everything else.
Well, there's got to be a way. I know you say this case is not the case where someone could establish the defense as a matter of law. But, I mean, you can imagine, can't you, some offer so out, again, but your focus is on the rejection of a tender
Right.
of an offer. But, and that did not occur here at all?
No.
Period. But there's got to be a way where a court can determine, basically as a matter of law, that a plaintiff was just unwilling to even entertain a reasonable offer.
Yes, and there, I mean, and we, again, they cite to a case, and I'm not going to remember its name, but I can look here and give it to you. I mean, in which they go through all of the evidence, and I believe it is a case where they decided that I don't know if it was as a matter of law, that there was sufficient evidence to support the jury's verdict. But certainly there are cases. I mean, if you have the facts where someone demands an amount that is more than what is owed. So again, it's easiest to see in a case where you have a contract that requires the payment of a sum certain. So it's a liquidated demand. And if you demand more than is due under the contract, and you refuse to accept a tender of the amount that's actually owed, then as a matter of law, you've established.
But if the Hayeses only wanted a new roof, right? If that's all they really wanted was a new roof, then why send a demand letter for $323,000 in actual damages or economic damages?
Because Mr. Hayes because Mr. Hayes and Mrs. Hayes waited for over a year. Mr. Hayes went to USAA and said, I want a roof, and they said no. Then Mr. Hayes went back to his lawyers, and they looked at the entirety of what could be recoverable under the contract and under the insurance code for the behavior that had occurred. And
But we're not talking about behavior or, tort damages here. We're talking about economic damages, provable damages.
Well, those economic damages, I would say, you
Not liquidated, but, there's a way to put a figure on this.
Right, there are, but those damages, though, include the fact that damage to the house, interior and exterior, without, seeing the claim file. Well,
For example,
trebled.
I could see mental anguish. Well, they demand $50,000. They don't put forward any evidence of mental anguish damages. You may have at some point in time thought, well, you were going to be entitled to mental anguish damages, but as you go through discovery or whatever, you figure out we're not going to get there. I can understand that. But the economic damages, where, you can pretty much put a price on a roof and, you're requesting 10 times the value of a roof.
Well, by the time this lawsuit's filed, it's not just the roof. There was much interior damage to this house, some of which they had paid for, some of which they had not. There was much more that was involved in this case from an economic standpoint once the lawsuit was going to be filed. But
go ahead.
I was just going to say, but again, I don't think it's appropriate when we're here looking at it from a JNOV standpoint and whether it's conclusively established to say we're going to take the inferences the way that the trial court ruled on the question. We ought to be looking at it from the other side. Is there any evidence? And we have evidence that a jury ought to be able to consider of, even if you think that this is too much to have demanded.
Right. Well, one way to look at this letter, I guess, would be the trial court or a fact finder, let's forget about the trial, a fact finder could look at this letter and possibly infer this was an unreasonable, excessive demand.
Yes.
A fact finder could also look at this very same letter and come to a reasonable conclusion, this was just an initial offer,
right.
And that's all it was an initial offer to get the ball rolling.
Right. That is exactly how we view it, is that, if we were here fighting over whether a jury finding could be, if there's some evidence in this letter to support a jury finding against us, then I'd have a very hard time standing in front of you.
Is this issue being submitted to juries? Are you asking for a bifurcation? I see the problem here, and I can see the potential for this happening.
To my knowledge, it has not yet been submitted to a jury, more often for many other reasons that are not directly, our supplemental response to the JNOV, for example, we point out to the court, since it's got this notice letter before it, that lots of cases settle after these kinds of notice letters are out there. This issue of this notice letter and whether it should come into evidence or not, there's so many things that are involved that so far this issue has not been submitted. An excessive demand question has not been submitted to a jury that I am aware of in these cases.
So what's the remedy here? Is it just a straightforward rendition point? We proved it, the jury found it, the trial court erred in granting the JNOV. If you prevail and we agree with you, trial court erred, it's just straightforward rendition, we enter the judgment the trial court should have rendered?
I believe that's where we are, Your Honor, because there isn't anything asking for a new trial on the other side. So I think that, and all they asked for was a JNOV.
Y'all presented some evidence to support the 237.5.
Yes. And now they raised cross issues on segregation and on the hourly rate testimony. We've addressed those. So we think But again, they are asking for a rendition of zero, not for a new trial.
And the issue on appeal is your issue, which is the trial court erred in granting the JNOV on this point.
That's right.
and there is no cross issue on in the USAA's appeal, no evidence to support 237.5. There's no argument like that, or is there? I can't remember.
Well,
I'll let them argue.
Okay, that's right, he can tell you. I think what,
I can't remember.
they do have additional cross arguments, and I'm sure Mr. Hovenatanian can address those.
Okay, thank you. We took you a few minutes over, but we won't take it away from you on rebuttal, but you'll have a little more time.
Thank you.
Thank you. Starting out with Ms. Hogan's first point, or it seems to be the primary point, is even if this defense applies here, and she doesn't concede that,
Right.
you look at this letter, and really this is all y'all are relying on is this letter.
Right.
A jury or a fact finder could from this letter infer that this was not the be-all, end-all final offer. This was really more of a fact finder could also interpret this letter as being, well, this is just getting the ball rolling. This isn't, that
Right.
kind. This isn't the, nuclear option or whatever.
Right. Well, and
if that's the case, then how did y'all prove it as a matter of law?
Well, Your Honor, the answer to your question is that's not the case, and Judge Ray was correct to conclude otherwise. And I'll tell you why. And I think we agree on one thing, all five of us, I think, which is that the notice letter is the key. And if the inquiry is based on the notice letter, then it's worth noting that it says demand is hereby made that the $621,000 is paid. Then on the next page it says this demand, and in the next sentence this demand, and then in the second to last paragraph this formal demand letter.
It is a demand letter.
It is a demand letter. It's a demand for $621,000. It's not intended to get the ball rolling.
Have you known of cases where a demand has been made and then the plaintiff has accepted a lot less than they initially demanded in their demand letter?
Thousands. I would respectfully suggest, though, this isn't one of them. And I'll explain that, returning again to the letter. The second paragraph of the letter refers to your liability. The next sentence says specifically, you are liable. In the middle of the next page, triggering liability on your part.
You don't expect a law firm seeking a settlement to say, well, you might be liable.
Right.
Or,
No, Your Honor, we would not. But my point is...
And your response, if you were to respond to this, would be, no, we're not. You
Right.
wouldn't say, well, maybe we are.
Well, well, that's true. We would say, no, we're not. But the problem with the letter from the excessive demand standpoint is that it says we demand $621,000. It continues to emphasize demand, demand, demand.
But isn't that just the first half of the inquiry? There also has to be this refusal to take 1 penny less.
Well,
how do you get there as a matter of law?
Actually, Your Honor, that's actually not the requirement. McAllister states it beautifully. The quote from McAllister is, a demand letter that states that the full demand must be tendered indicates a refusal to accept tender of a lesser amount. So the question is, does this letter indicate that this is what we'll take and we won't take anything less?
Well, what
That's
about
exactly what it indicates.
What about the language Ms. Hogan pointed out about the fact that we're making in the spirit of compromise? There's some other language I think she pointed out that
Correct, Your
says,
Honor, about the savings.
right, well, yeah, and it's compromise.
Write me back.
Right.
Yeah.
Well,
yeah.
but to be fair, it says this demand is made in the spirit of compromise. So we're demanding that you pay us $620,000 in the spirit of compromise. And then it goes on to say, actually, this is a, quote, tremendous savings, unquote. So you're getting a bargain by paying us $620,000. And what they ask for a response to is not write us back and tell us how your family's doing. It's, we trust you will immediately respond in writing to this formal demand letter. The writing they have there is writing your name on a check and sending it to their lawyers. And there's nothing wrong with that.
I mean, you're reading this letter as if it says, we will accept nothing less than.
Well, Your Honor, that's a fair correct. I certainly.
They don't use that express language, but
They do
you're
not.
saying that's the only inference you could draw after reading this letter was that this was a take it or leave it offer.
And you continue to use the word demand. Should they have said we request, we respectfully request?
Well, if the letter is really meant to say, let's get the ball rolling, how come it doesn't say that? It says, we demand $620,000.
Demand letters never say that, do they?
Your Honor, respectfully, and this is outside the record, of course, but respectfully, frequently they do.
Okay.
They do.
But not always.
Not always. Absolutely true. Absolutely true.
And even in the case where it's not always, the plaintiff will usually end up accepting a lot less than they initially demanded.
That's true, but in this case, though, Judge Ray is not required to conclude that would have happened here. And in fact, the evidence was to the contrary. In March 2011, USAA offered $32,000 to the Hayes on top of the $24,000 they had already paid them. The Hayes said no. That wound up being more money than the Hayes were awarded in actual damages.
Even if we were to agree with you about the letter, you'd still have this situation of, well, how do you value a case? Because both sides could put a value on a case, and a jury could come back with a zero finding or a $30,000 finding when there might have been some evidence to support $320,000
Sure.
in economic damages. You can't just base it on hindsight, based on an ultimate finding.
Agreed, Your Honor. It has to be, I think, and again, I don't want to go too broad here. I think we all agree that what we're talking about is the evidence in the record. In other words, what the Hayes proved. That's the standard. You look at what was demanded and then compare it to what was proved. And in that regard, we talked a little about the attorney's fees. It's not so much that the jury awarded $237,500 as what the Hayes proved. Their own attorney's fee recap, which is the title of the exhibit, showed that as of the date of the notice letter, October 1st, 2009, they had run up $952.50 in attorney's fees for 5 hours of work. $952. And yet the October 1st, 2009 demand letter says that'll be $250,000 for expenses, including attorney's fees. That's the kind of record that Judge Ray had in front of her. Not $250,000 in attorney's fees, but their own evidence, their own attorney fee recap showing as of the date of the notice letter, $952. It's that kind of evidence that would lead one to conclude, when comparing it to the letter, this is an outrageous and an excessive demand. And one other thing, one other point deserves mention here. This demand letter is not the same as Mr. Hayes telling inspectors, I want a new roof. We suggest you can't look at this record fairly and say, well, here's some other demands. Now, there's case law that says, Pennington says this, or I beg your pardon, Outdoor Systems says this, Aero DFW says this, 2 cases cited in our brief, that when there's a string of demands, you look at the last demand. But you don't even need to go that far in this case. It's not a demand when you tell an inspector at your house, I want a new roof. It is a demand when you write the president of the company, Major General Robles, and tell him you owe me $600,000 without an invitation to negotiate, even if it's in the spirit of compromise, that we're demanding $620,000.
How does this shake out? Let's say we were hypothetically to disagree with you and find in favor of the Hayeses on this issue. Because of the posture of it, it was a J&OB, the trial court granted it.
Correct.
Let's say we, looking at it from the other perspective, what would be the remedy here? Is it a rendition, simply a rendition? I don't really see any cross-point. I mean, you attacked in your brief the breach of contract finding,
right?
The cost that shouldn't have been entered into the final judgment,
right?
And then the amount of the cost.
Well, Your Honor, we argue that in our Appellee's brief that if you disagree on excessive demand, there are other reasons why attorney's fees should not have been awarded.
Okay.
The short version of that is segregation and evidence. And so, were you hypothetically, I hope, to disagree with us, I respectfully suggest Right, then you go to those
That's in your other,
alternative
that's in your
arguments.
other brief, excuse me.
Correct, Your Honor.
Okay. Okay. We still haven't talked about shingles, and you got about, is there anything, I mean, this case really went by very fast. Is there anything else any point you'd like to make that we didn't really get into?
Not necessarily. I mean, I can.
And this is the big issue.
Correct. It is. And Ms. Hogan and I talked yesterday, and we were kind of laughing about it, and we agreed that this is certainly the biggest issue in the case monetarily. And so I think that's why both sides have spent so much time on it. If I was going to say anything about shingles, I would say only that, if I can have the court's indulgence, sure. I would say if you're going to prove that a shingle came unsealed because of Hurricane Ike, there has to be some evidence that the shingle was sealed prior to Hurricane Ike.
Well, I mean, they have to prove that it's more likely than not.
Correct.
The damage was caused by Hurricane
Right,
Ike.
a preponderance of the evidence.
That doesn't mean that anybody who buys a roof in order to recover on their insurance that covers their roof, that they have to have their roof periodically inspected so that they can prove that, at a certain point in time.
True. We wouldn't go that far.
It seems like you're setting up almost an impossible to meet standard there, when really the standard really is preponderance of the evidence.
It is preponderance of evidence, Your Honor. But our argument is you can't show causation. You can't show Hurricane Ike caused the unsealing if you can't show they were sealed to begin with.
Why isn't that just a jury issue for the plaintiff to present evidence? Hey, the roof was fine before Hurricane Ike, and we have our experts to say it was fine before Hurricane Ike, and then you present your experts to say, no, it must have been something else.
That's exactly what it is. It is a jury issue. Our argument is they just didn't show any evidence on that, and in fact, the best point...
No, your point is their evidence amounts to no evidence, really,
Correct.
Because they didn't establish that before Hurricane Ike, their roof was properly sealed.
Correct. Or, to quote their own expert, Mr. Rabner, we don't know what was sealed before Ike. Well, then you can't possibly meet causation and recover for unsealed shingles.
Then no one would ever be able to recover for damage to their roof, would they?
No, Your Honor, a homeowner who could testify what the condition was in, who could say unequivocally, those shingles were sealed, there was no issue with my roof before the hurricane, that homeowner could recover, and homeowners have.
Didn't they kind of say that there was no wavy roof or anything like that before Hurricane Ike? And
well,
then after Hurricane Ike, the roof was wavy?
Well, Your Honor, that happened, but the problem is, first of all, if you look at the photographs, it's hard to find any waves. And of course, the second issue there...
They testified to it, and the jury could believe their testimony,
well,
regardless of what the photographs look like.
If you were to conclude that waviness on the roof means the shingles were not sealed before the hurricane, but it's not proof that they were sealed before the hurricane.
Right.
And so for that reason...
You don't think this is kind of an impossible to meet standard?
Your Honor, respectfully, I don't, and other homeowners have met it in other cases. The Hayes can't meet it here because they can't...
What exactly do they have to prove to get to that preponderance of the evidence level? What exactly does a homeowner have to prove?
They have to show that the shingles on the roof that allegedly were unsealed by the hurricane were sealed before the hurricane.
And how do they show that? Just by testifying the roof worked and it didn't leak and it...
Well, that's part of it, because, and the reason I say that's part of it is because even unsealed shingles can shed water.
That's not good enough to say, well, we never had a leak, we never had a problem before. That's not good enough. They have to have some direct evidence in regard to the sealing of the roof. That
correct.
It was.
That's correct. And the reason has its basis in science, in that even an unsealed shingle, not easy to say apparently, even an unsealed shingle will shed water and protect the roof. And so it's incumbent on the homeowner to say, I know my roof, those shingles were sealed. Or if the homeowner can't do that, at least to be able to say, look, my roof was one way before the hurricane and another way after the hurricane.
I bet you if you asked most homeowners in this state, they wouldn't know what the difference is between a sealed and an unsealed shingle is.
That may be true, Your Honor. That may be true. But
in which case, most of us are going to be out of luck.
Well, I hope not. But that makes all the difference in terms of causation and in terms of being able to show, to specify, yes, it was Hurricane Ike that caused this damage.
Appreciate it. Thank you.
Certainly.
please the court. Let me start with this last argument on shingles so that we'll have something else to talk about with the court. USAA paid to reseal shingles in this case. They came into, before they came into court, they sent court, they had estimates done, they developed documents, they sent an estimate and they sent a letter to Mr. Hayes, all of which indicated that this claim for unsealed shingles was being paid under the policy. There was no suggestion prior to trial that this was not a covered loss. They admitted that this was a covered loss in all of their communications with Mr. Hayes following their final inspection when they reached the point that they were going to pay. So to suggest that there isn't evidence in this record that this was a covered loss or that we had to have some evidence of before and after, we did, but to suggest that we have to have that, again, ignores the standard of review because they themselves determined that this was a covered loss. Now, USAA also took the position at trial then, oh, no, it wasn't really, no, we don't really mean that it was a covered loss. Yes, we wrote the Hayes and we told them that it was a covered loss and we paid them. We took a deductible, we told them that we're paying actual cash value and we calculated replacement cost value just like the policy says, but we didn't really mean that. Well, the jury gets to disregard that part about we didn't really mean that, at least for answering the breach of contract question. They inspected this roof. They determined that these unsealed shingles were covered under the policy. That's the principal evidence that we would rely upon. We also have our expert. We detail why his testimony, of course, is sufficient. It's no different than a doctor saying, I don't know the condition of this plaintiff's back beforehand, but I can tell you that afterwards, in my understanding, based on my review, I don't know, but I can tell you based on my experience and my expertise that the accident caused the discs problem. There's no difference in the way Mr. Rabner approached this case. And then in addition to that, we have cited it. Mr. Hayes didn't have to climb up on the roof in advance and try and lift shingles, and that's not the standard. But what we do have is both Mr. Hayes and Mrs. Hayes testified that before they purchased this house, and at the time they purchased this house, which was 4 years before Ike, that the roof was fine, that it looked just fine, and that after this, that the roof was wavy. And again, and the suggestion that the pictures don't show it, colored pictures, not black and white grainy pictures. The pictures that we cite to in our brief are colored photos taken by USAA's last adjuster, and they absolutely show the waviness of the roof. Reporter's Record, Volume 11, page 210. The second photo, I can hand these to the court if you would like.
The jury, they testified.
That's right.
There was evidence introduced.
Yes, Volume 11, page 211, top picture, pretty wavy. The jury certainly got to look at these color photographs and believe the Hayes when they testified. Our roof didn't look like that before.
Any response on the attorney's fees issues in regard to Mr., I guess they're not really cross points, but they're conditional grounds to attack the attorney's fees?
Yes, I mean, we have
other grounds
we have briefed those, and we do not believe that there is a basis for, again, to be able to right. I mean, we offered the testimony of segregation. There was no objection to it. We offered testimony on the hourly rates. There's a complaint that the testimony about hourly rates from our side included overhead expenses, and that's that our hourly rates are higher because we have to cover expenses, our overhead. Again, at trial, that testimony came in from our side. There was much discussion about all of the things that went into rates, and there's much other evidence about rates. And then on their side, they simply put on evidence that, no, you shouldn't consider the overhead expenses, and here's what we offer as rates. And the jury picked a number that was less than the total that we argued was supported, about $100,000 less than the evidence that we put on as evidence through trial for attorney's fees. So obviously somewhere in there the jury decided that either the hourly rates were too high or there's some additional hours, but again there is no basis on which the trial court could have rendered judgment against us on attorney's fees on those grounds. Thank you very much.
Cause number 0114000133 CV USAA versus the Hayeses is now submitted. Thank you all.
All right.